Enforceable by law. Enforceable by law. So what are the so what does the examiner maybe expect you to do or to learn about this law of contract? First of all, he only need you to know about type of contract. Then he also need you to know about what? Element of contract. And lastly, we need you to know about the remedies available, remedies in contract. Hizo vitu tatu hizo. Lakini maswali mingi they are based on this. Maswali mingi za contract they are based on the element of contract. So let's start with type of contract. After knowing what's a contract, let's start with type of contract. So type of contract, there are more than 15. Type of contract, there are more than 15. So number one, we say contract of record. Number one, we have contract of record. Contract of record, you say, they include judgment of court and personal recognition into bracket promise by way of bond. They include judgment of court and personal recognition into bracket promise by way of bond. They are not true contracts. Because the obligation under them are imposed on the parties by the court. Obligation under them are imposed on the party by courts and do not resort through mutual agreement. Obligation and on them are imposed on parties by the court and do not resort through mutual agreement. Number two, we have specialty contract, you say, these are formal contracts, which must be in writing, signed, sealed, and delivered by party. These are formal contracts which must be in writing, signed, sealed, and delivered by parties to be bound to the person whose benefit was made and delivered by the party to be bound to the person for whose benefit it was made, Then number three, we're talking about simple contracts. Simple contract, you say, it is one that does not satisfy the requirement of a special contract. It is one that does not satisfy the requirement of a special contract. It is one that does not satisfy the requirement of a special contract. Number four, we have express contract. Okay. It is one which parties agrees. It is one which parties agree, whether orally or writing, about the nature. It's one which parties agree, whether orally or in writing, about the nature and the bound term of their relationship, and the bound terms of their relationship. E.g., sale of a vehicle, e.g., sale of a vehicle, e.g., sale of a vehicle. E.g., sale of a vehicle, sale of a vehicle. Then number 5, we have implied contract, implied contract. Implied contract. So implied here, it means what? Assumed, okay? It means assumed. So you say, there is no specific agreement. There is no specific agreement, but it is inferred from the conduct of the parties. But it is inferred from the conduct of the parties, as well as the surrounding circumstance. As well as surrounding circumstance. There is no specific agreement, but it is inferred from the conduct of the parties, as well as surrounding circumstance. E.g., boarding of a taxi, boarding of a taxi, e.g., boarding of a taxi. Then number 6, we have another category here known as contract of obey, contract of obey, may obey, contract of obey, uberimai, 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 fidei, uberimai fidei, uberimai fidei, uberimai fidei, or good utmost faith, good utmost faith, good utmost faith, good utmost faith, good utmost faith. You say these are contracts. These are contracts which require a party to disclose material facts. Which require a party to disclose material facts. They have knowledge of the other party. They have knowledge of the other party. Which require a party to disclose material facts. Material fact they have knowledge of the other party, e.g., insurance contract, e.g., insurance contract, family settlement, partnership and agencies, partnership and agencies, partnership and agencies, partnership and agencies, partnership and agencies. Then number 7. Number 7, we have what? We have execution. We have execution. Execution, you say. So tuko na hizi majina mbili, we have execution and we also have executory. Executory, we have these two terms, execution and executor. So execution, you say, execution, this is where both party completely perform their share of obligation. Completely perform their share of obligation in a contract. Completely perform their share of completely perform their share of obligation in a contract. Then executory. Executory, executory, you say, this is one which both the obligation are outstanding on either parties on the contract. This is the contract. This is the one which both of the obligation are outstanding on either part of the contract, either wholly or partially, either wholly or partially, either wholly or partially. So let's talk about these two. So execution, we are saying, hapa hivi ni ile contract ambayo the parties have already undertaken the contract. The party has already undertaken the contract. They have already, even if it is payment, they have already paid, okay? And if the other party is to maybe to bring workers to start doing a function, it has already also brought those workers and they have started to do some work. Are we together? Yeah, but if we're talking about executory, it's a promise on a promise, okay? Yeah, if you do this, I will do this. If you do the, if you pay my money, then I will work for you. Are we together? If you pay your money, then I will work for you. So those are the one we are calling what? Executory contract. Executory contract. They are promised. They have the promise on a promise. So those are the one we are calling executory contract. Then you also have another one. You can write bilateral. Bilateral. So bilateral contract, bilateral contract. Bilateral contract. Number 9, we are talking about bilateral contract. Bilateral contract. Bilateral contract, you say. Bilateral contract. So this is a contract. This is a contract that bind both parties to it. This is a contract that bind both parties to it. Number 10, we're talking about unilateral. Unilateral contract, unilateral contract, unilateral contract, unilateral contract. We say it's a contract. It's a contract in which one party is bound. In which one party is bound. It's a contract in which one party is bound. E.g., promise to reward someone. E.g., promise to reward someone. Yeah. How many were in Kenya when those people break from committee? How many were in Kenya? You were in Kenya. So government promised that whoever will get these people will be paid how much? Yeah. Yes. What was the consideration for you giving information about those people? Ilikuwa last year, msijifanya hamkuwa, you are here. Ama msikiangi news. Naonanga tu TikTok peke yake. Okay, so it was a reward of 1 million. Is it 1 million or 10 million? I don't know. So such contract is a unilateral contract where one part promised to do something, okay? Only if you fulfill another, they only fulfill that obligation, then the one party will do that. Are we together? But bilateral is now the agreement that you enter between the two. You must do this and you must do this so that this can be done, okay? That's what we refer as bilateral. So have you gotten the difference between unilateral and bilateral? So unilateral is only one party that's obliged to fulfill the promise. But in bilateral, both parties have to fulfill the responsibility or obligation on the contract. Then we have this unavoidable, voidable, and we also have valid contract, voidable, and also have valid contract. So you say valid contract is an agreement which is binding. Valid contract is an agreement which is binding. It's an agreement which is binding and enforceable by law, and enforceable by law. Enforceable by law. Void contract is an agreement that is binding. It's an agreement that is binding, but because of lack of one or more, essential of a valid contract, it may be set aside. But because of lack of one or more, essential of a valid contract, it may be set aside. Then we have void contract. Void contract is one which is completely destitute of any legal effect. Is one which is completely destitute of any legal effect. And it cannot maintain a legal action against the other, and it cannot maintain a legal action against the other, and it cannot maintain a legal action against the other. So those are the void, voidable, and valid. Void, voidable, and valid. Void, voidable, and valid. Then lastly, we have written contracts. Number 10, we have 11 written contract. Written contract, you say, these are contracts that must be in writing. Otherwise, they are void. E.g., all contracts that require to be stamped, all contracts that require to be stamped, they must be written, e.g. all contracts that require to be stamped, they must be written, comma. We also have acknowledgement of the statute date, acknowledgement of the statute birth date must be in writing, acknowledgement of the statute birth date must be in writing. Another one, transfer of immovable asset, transfer of immovable asset, transfer of immovable asset. And lastly, we have bill of exchange, and promissory note, bill of exchange and promissory note. All those are contracts that require to be written. All those are the contracts required to be in writing. And lastly, let's check on contract evidence in writing. Number 12, we have contract evidence in writing, contract evidence in writing. Contract evidence in writing, contract evidence in writing. Contract evidence in writing. Writing, so say, evidence by some note or memorandum must be supported by written evidence. Evidence by some notes or memorandum which must be supported by written evidence, e.g. a receipt, e.g. a receipt, e.g. a receipt, e.g. a receipt, e.g. a receipt. So example of such contracts, we have contract of guarantee, contract of guarantee. Also have agreement of sale of land, hire purchase, employment contract, employment contract. Nani hapa shaifanya kazi? Sio kibarua ya sikwenda na kurudi, nasema kazi ya kuandikwa, employment contract, okay? You must sign an employment contract. So that's just an evidence that you have a contract with the one you are working with. Are we together? That's an evidence that you have a contract with the one you are working with. So those are the type of contract. Those are the type of contract we have. Those are the type of contract we have. Those are the type of contract we have. So let's look at the element of the contract, element of contract. So maswali mingi sana inakuja hapa. So we have 8 elements. We have 8 elements of a contract. Number 1, we have offer. Number 2, we have acceptance. Number 3, we have intention. Number 4, we have consideration. Number 5, we have capacity. Number 6, we have what? Legality. Number 7, we have consent. And number 8, we have what? Performance. We have performance. Number 8, we have performance. So those are the elements of a contract. Those are the elements of a contract. Yes. Yeah. Sorry for that. I hope you can hear. What work bargain? Are you in the house? Are those people who like bargaining? Okay, that is a counter. Or if I tell you that this book I'm selling at 10 shilling, okay? I'm selling this book at 10 shilling, but you are doing what? You wanted me to sell you at this book at 7 shillings. So that's a counter offer. That's a counter offer. So I tell you the original price, you change the term of the original contract. That's a counter offer. Then cross offer. Cross offer. What Ramadharau? Ramadharau, are you in the house? Yes? Oh, amuko. Sawa, kunao watu basi. So cross offer, I see you lack something, okay? I see you lack something. Like now you can lack what? What can you lack, please? But not money, okay? But not money, okay? Anything that you need, you can need what? Shoes, okay? I see you lack shoes. I brought you shoes that I have bought. I tell you that I have an offer. I want to give you these shoes. Maybe those shoes are being sold at 500. Then I bring to you those shoes. I tell you that I want to sell you these shoes at maybe the price of 400 shillings because I see you are in need of it, okay? Instead of you answering me answering me whether you'll buy or you'll not buy, you also go and bring the exact shoes, okay? The exact shoes, exact color, exact size. You tell me, I'm also selling these shoes at 400. That is a cross offer. That is a cross offer, okay? Yeah, you encounter another party with whatever he's selling to you. You also bring the same thing you want to sell to him. Are we together? Then standing offer or single offer is where now maybe you have been told to bring some or to deliver something of a certain quantity at a certain time, okay? So if you fail one of those terms, then that offer will be cancelled. That offer will be cancelled. Are we together? Then conditional offer, you must fulfill the conditions that are required for you to enter into such offer. If it is maybe age above 18, you must be above 18. Are we together? And those are the type of offer. Those are the type of offer. Gani hujaelewa? Gani hujaelewa turudie? So if you have understand, let's write counter offer. Counter offer. It is a reply to an offer. It's a reply to an offer which varies the term of original offer. Which varies the term of original offer. Which varies the term of original offer. It operates as a rejection to the original offer. It operates as a rejection to the original offer. It operates as a rejection to the original offer. It operates as a rejection to the original offer. Number 2, we have cross offer. Cross offer. Number 2, we have cross offer. It is where parties make identical offer to each other. It's where parties make identical offer to each other. Ignorance of each other's offer. Ignorance of each other offer. Ignorance of each other offer. Ignorance of each other offer. Then conditional offer. Conditional offer. Say this is an offer. This is an offer. This is an offer made subject to certain condition precedent. This is an offer made subject to certain condition precedent as may imposed by offeror, or implied by law, Single offer, single and standing offer. It is common in tender. Where the tenderer is required to supply a definite quantity of goods, within specified period. Is common in tender where the tenderer is required to supply a definite quantity of goods within specified period. Acceptance of single offer gives rise to a single contractual breach of any term. Of the contract will amount to the breach of the entire contract. They are saying acceptance of single offer give rise to a single contractual breach of any term of the contract will amount to breach of the entire contract. So those are the type of contract. So let's check on rules of an offer. Number one, an offer can be made to specific person, to any member of the public, or group, and to the world at large. An offer can be made to a specific person, to any member of the public or group, and to the world at large. Number two, an offer may be made by word of mouth, in writing, or by conduct of the party. An offer may be made by word of mouth, in writing, or by conduct of the party, Number three, an offer must contemplate giving rise to a legal consequence if accepted. An offer must contemplate giving rise to a legal consequence if accepted. The terms of the offer must be certain and free from ambiguities. and free from ambiguities in expression. The term of offer must be certain and free from ambiguity and free from ambiguity and free from ambiguity from expression. Number 5. We're talking about every offer must be communicated. Every offer must be communicated. Every offer must be communicated, and therefore, every offer must be communicated, and therefore, cannot be accepted. Cannot be accepted by a person who does not know about it, and therefore cannot be accepted by a person who does not know about it. Every offer must be communicated and therefore cannot be accepted by a person who does not know about it. Rule number 6. Rule number 6. Silence is not acceptance of an offer. Silence is not acceptance of an offer. Silence is not acceptance of an offer. Silence is not an acceptance of an offer. Rule number 7. Offer may attach any condition to, or offerer may attach any condition to his offer. Offerer may attach any condition to his offer, but must be communicated before acceptance. Offerer may attach any condition to his offer, but must be communicated before acceptance. But must be communicated before acceptance. But must be communicated before acceptance. Then the last one. The last one. Offer must distinguish itself from. Offer must distinguish itself from Roman 1. Offer must distinguish itself from Roman 1. A mere supply of information. Mere supply of information. A mere supply of information. Then Roman 2, a mere declaration, a mere declaration, a mere declaration of intention, a mere declaration of intention. And Roman 3, you have an invitation to treaty, an invitation to treaty, an invitation to treaty. An invitation to treaty. So we are saying a mere supply of information is where now, how many have visited supermarket? Unaona wameweka hapo kitu labda wameweka hapo duve. Wameweka hapo anauza 200 shilling, okay? 200 shilling. So you go there, you think that you can pay for 200 shilling. That's a mere supply of information. You are told that this duvet may be the cheapest one is 2,500. 2,500. Are we together? So that's a mere supply of information. Or a bus fare, unaambiwa make hapo from this area to this area, maybe it is 20 shilling. You go there, you are told that the fare is maybe 100 shillings. So that's just a mere supply of information. It is not an offer unless it is written there. Offer, unless it is written there. Offer. Are we together? Then an intention, a mere declaration of an intention. A mere declaration of an intention is whereby someone can say, like you now, you can tell me that I am going to register for CASNEB examination, okay? I'm going to register for CASNEB examination. Come April, you don't do exam, you don't do exam. So I cannot rely to your statement that you are going to register examination. Neither can I hold you. Can I hold you that you told me that you are doing so? It was just a declaration of an intention, a declaration of an intention, but it was not an offer. Are we together? It was not an offer. So this happens usually in auction, okay? When someone here that they are going to be an auctioneer of something, maybe that thing, this person is in need of, okay? If you hear there will be an auctioneer of something that you are in need of, you will do all the way you can so that you reach on that auction market. But reaching there, if you find there is no auction, then the first thing you will do what? You will sue those people who announce such information. So, but in most cases, it's a mere declaration of an intention. I did not guarantee you that it must be happened, but I was just intending to do it, okay? So if I don't do it, you cannot sue me for it. That's a mere declaration of an intention. Then an invitation to treaty, an invitation to treaty, write that. Andika hiyo, an invitation to treaty. It is a mere invitation of a party. It's a mere invitation of a party to another to make an offer or bargain, to another to make an offer or bargain, to make an offer or bargain, to make an offer or bargain. So it was a question in November 2020, question 3B. So examples of invitation to treaty. Examples of invitation to treaty. Roman 1, invitation to tender. Invitation to tender. Advertisement for job. Advertisement for job. Sale by display. Sale by display. Sale by display. Brochure of a college. Brochure of a college. Brochure of a college. Brochure of a college. Timetable of bus companies. Timetable of bus companies. Timetable of bus company. Timetable of bus companies. So all those are an invitation to treaty, okay? Yeah, you can be told that maybe you are traveling, this bus will be offset maybe at 7 a.m. So by 7 uko hapo na basi inakuja kutoka saa 5. It was not an offer, but it was just an invitation for treaty. Ilikuwa tu inakaribisha mwingie kwa biashara. And that also happened with college. Like if you look at KCE brochure, imeandikwa hapo kama learn CPA at 8,000. Come and learn CPA at 8,000. But in recent, if you come, you'll be told that 8,000 is only for 1 unit, okay? It's only for 1 unit. So you are just being invited to do business, but you are not maybe being invited as an offer that will learn the entire CPA at 8,000. Are we together? So that's an invitation to treat, and those are the rule of an offer. Those are the rule of an offer. Let's check termination. Termination of an offer. Termination of an offer. Termination of an offer. It was also a question on November 2020, question 3B2. November 2020, question 3B2. Number 1 is by revocation. Revocation or withdrawal by the offerer. Revocation or withdrawal by the offerer. Number 2, it cannot be terminated by rejection by offeree. Rejection by offeree. Rejection by offeree. Number 3, counter offer. Counter offer. Counter offer. Counter offer can also terminate an offer. Counter offer can also terminate an offer. Number 4, lapse of time. Lapse of time. Lapse of time. Number 5, Failure to fulfill a condition. Failure to fulfill a condition. Next, death of either party, death of either party, death of either party. And lastly, insanity of a party, insanity of a party, insanity of a party. So before we finish on an offer, let's write rules of revocation, rules of revocation, rules of revocation. So revocation, we said, is withdrawal by the offeree, withdrawal of the offer by offeree. So what are the rules? Number one, an offer is irrevocable. An offer is irrevocable after acceptance. An offer is irrevocable after acceptance. An offer is irrevocable after acceptance. Number two, notice of revocation must be communicated to offeree. Notice of revocation must be communicated by offeree. Then number three, revocation become legal. Revocation become legal when the notice is received by offeree. Revocation become legal when the notice is received by offeree. Number four, an offer is revocable at any time before it become effectively accepted. An offer is revocable at any time before it become effectively accepted. And lastly, a bid at the auction is irrevocable. A bid at the auction is irrevocable before the hammer falls, before the hammer falls, before the hammer falls. So how many have ever attended auctioneer markets here? How many have ever attended auctioneer markets? Ama hata mjue ni nini, mnaisikia leo. Okay? Do you know what's auctioneer markets? Mnaisikia inaitwa nipotea pata ama somehow like that, okay? But it's where you take something, but people do what? Buy by bidding, buy by bidding. The highest bidder will take, okay? Like I can start to bid this pen. I say, I'm selling this pen at 1 shilling, okay? Then another person comes. Since it's an auction, there is a rule. You cannot remain on that, okay? Another person come and say, I will buy that pen at 10 shilling, okay? The other part seeing that, he said that I'll buy this pen at 50 shillings. So the bidding goes as it rises. So the highest bidder will be the one who will buy that phone. Are we together? The highest bidder. So we are saying a bid in auction is irrevocable before the hammer sells. Ukianza tu 1 shilling, mpaka ule mtu wa mwisho akimalizia hata na 1000 ama 2000 na asitoe pesa, hapo ndio unaweza revoke the offer. But once the auction is continuing, you cannot revoke the offer that you are selling that thing. Are we together? Kama umeelewa ni hivyo. So that is the first element of a contract. That's the first element of a contract. Number two, acceptance. 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 You say it is external manifestation of an offer by offeree. It is external manifestation by offeree. It is external manifestation of assent by offeree. It gives rise to the agreement between them. It gives rise to the agreement between the parties. To give rise to the agreement between the parties. So rules of acceptance, rules of acceptance, rules of acceptance. Number one, it can be orally, written, or implied from the conduct of the party. It can be orally, written, or implied from the conduct of the party. Number two, offeree must be aware of the offer. Offeree must be aware of the offer. Offeree must be aware of the offer. Number three, it should be unconditional and unqualified. It should be unconditional and qualified. It should be unconditional and unqualified. It should be unconditional and unqualified. Also, we have, it must be communicated to the offerer. It must be communicated to the offerer. It must be communicated to the offerer. If the offer was to a class of person, if the offer was to a class of person, can only be accepted to a member of that class. If the offer was to a class of person, can only be accepted to the member of that class. It can be through telephone, can be through telephone, can be through telephone or postal, if the rules or if the terms allow so. It can be through telephone or postal if the term allows so. Then another one. An offer must be accepted during stipulated time, or within reasonable time. Stipulated time or within reasonable time. Number three, intention. Number three, intention. Number three, intention. Intention, right there, intention. Intention. Intention, you say. Intention, you say. Parties to contracts must have intended to create a legal binding relation. Parties to contract must have intended to create a legal binding relation. A legal binding relation. Nature or type of agreement, nature or type of agreement, nature or type of agreement, nature or type of agreement. Number one, we have domestic. We have domestic social agreement. We have domestic social agreement. You say there is no intention to create legal relationship. There is no intention to create legal relationship. E.g., agreement between a husband and a wife, comma. There is no intention to create a legal relationship, e.g., agreement between a husband and a wife, comma. Parent and a child, parent and Child, yeah, if you have a husband or a boyfriend, he tells you that I'll buy you what? Naitwa nini? Kano, unajua kano? Okay, have you ever come across this? If you have a husband or a boyfriend, he tells you that I'll buy you a kano this year. A kano ni meli, okay? Kind of a meli. Anakwambia, wewe umenipendeza sana, huu mwaka lazima nikununulie meli yako. So you cannot go and sue your husband. You cannot go and sue your husband or your boyfriend because he promised to buy you a kano. Are we together? Yeah, that's what we meant, that that's a social or domestic agreement. It's not binding. It is not binding, okay? Yeah, maybe it was just a way of making you happy. Maybe umekaa kwa nyumba umekasirika mchana wote, or along the phone you were just saying some harsh words, so he want to make you come back to the normal life. So he just promised something that will make you at least feel happy. That's a domestic agreement. That's a domestic agreement. Then number 2, we have business or commercial agreement. Business or commercial agreement. Business or commercial agreement. Business or commercial agreement. We say there is an intention to create legal relation. 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 E.g., advertisement, employment agreement, employment agreement, employment agreement. So that is the number 3, intention. That is number 3, intention. Let's check on consideration. Let's check on consideration. Let's check on consideration number 4. So you say consideration number 4. Say it is the price. It is the price or promise. It is the price or promise made by one party to another. It is the price or promise made by one party to another. It is the price or promise made by one party to another. Then you write there type of consideration, type of consideration, type of consideration. The price is the price made by one person to another. It is the price made by one person to another. So type of consideration, type of consideration, type of consideration. Number 1, you have execution, executed. You have executed consideration, executed consideration, consideration, executed consideration. You say it is something actually done. It's something actually done. It's something actually done. Or suffered by making a contract. By making a contract. It's something actually done or suffered by making a contract, comma. It is a price promise and already paid. It's a price promise and already paid. It's a price promise and already paid. Then number 2. So sometimes we call it present consideration. Sometimes we call it present consideration. Present consideration. Consideration. Number 2, we have executory. 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 Executory or future. Executory or future consideration. Future consideration. You say it is a promise on a promise. It's a promise on a promise. It's a promise on a promise. It's a promise on a promise. This is where neither the parties has performed part of the contract. This is where neither the party has performed part of the contract, nor repaid any price, nor repaid any price. Then the last one is past consideration. The last one is past consideration, past consideration, past consideration, past consideration, past consideration. Past consideration, we say, it is a promise made, it's a promise made after the service have been rendered. After the service have been rendered. Ya wewe ulifanya kazi, mtu amekuita ufanye kazi, ushafanya kazi na mtu anakuambia nitakulipa next year. Nitakulipa next year. So that's a past consideration. So another point, past consideration is not sufficient to support a contractual claim. Past consideration is not sufficient to support a contractual claim. Past consideration is not sufficient to support a contractual claim. Contractual claim. So subheading hapo, exemption to rule of past consideration. 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 Exemption rule of past consideration. Number one, where there was acknowledgement of star bad debt, bad debt, of star bad debt, bad debt. Number two, talking about what? Where there was use of negotiable instrument, where there was use of negotiable instrument, negotiable instrument, and number three, we have the last one, rendering service on the request of defendant, rendering service on the request of defendant, rendering service on the request of defendant, rendering service on the request of defendant. So those are the three exemptions to the rule of past consideration. So past consideration, we have said, is where you do the work, okay? You do the work, and then the other party, instead of paying you, it tell you that it will pay you in future. It will pay you in future. So that's a past consideration. That's a past consideration. You cannot go and sue someone for that. You cannot go and sue someone for that. But then, if any of these three reasons involved in that consideration, then you can sue, like acknowledgement of statute bad debt, okay? Kama mlisainiana, uliambia acha tuandikishane, utanilipa hiyo tarehe unasema, then that person cannot do what? Cannot say that he did not provide the service, or he cannot deny that he will pay you. Are we together? Yeah, then because date, signing someone date is run for how long, which period? 6 years, okay? Kama umekopa na uko na deni ya mtu mahali na mliandikishana, tafadhali enda ulipe, because he can sue you within the first year to the 6th years. So uombe tu bahati asahau, bahati asiposahau atakupeleka kwa koti. Kama ulisign, kama uligaranti mtu na ukasign, please go and pay. Go and pay, because that debt ran for 6 years before that thing is being done away with. Then, where there was use of negotiable instrument, where there was use of negotiable instrument, like bill of exchange, okay? Like bill of exchange or check, okay? Yeah, you used a check maybe to provide a service, and this person kept maybe the photocopy of that check, okay? You cannot deny that you cannot pay such person. And also, where the service were given on the request of defendant, paka ndiye alikutumia fare mahali ulikuwa, ukatoka huko, ukakuja kumfanyia kazi. He cannot deny that. He cannot deny that he will not pay you, okay? So those are the exemption of that. Those are the exemption of that what? Of that first consideration. So those are type of consideration, type of consideration. Let's check on now on rule of consideration, rule of consideration, rule of consideration, rule of consideration, rules of consideration. So remember, consideration, we say is a price of the contract, a price of the contract. So rules of consideration, rules of consideration. Rules of consideration, rules of consideration, rules of consideration. Number one, consideration must not be passed. 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 Number two, consideration must be real. Consideration must be real, i.e., consideration must be real, i.e., it must have something of value in the eye of law. It must have something of value in the eye of law. It must have something of value in the eye of law. Number three, consideration must be sufficient. Consideration must be sufficient, although need not to be adequate. Although need not to be adequate. Consideration must be sufficient, although need not to be adequate. Another one. Consideration must be legal. Consideration must be legal. Yeah, something illegal is also not, because it's also not considered as consideration. Consideration must be legal. Consideration must be legal. Number five. Number five. Mutual love and affection is not sufficient consideration. Hiyo ni sheria inasema. Mutual love and affection is not sufficient consideration. Unless it's a bequest, unless it's a bequest, unless it's a bequest, unless it's a bequest, bequest into bracket, gift under will, gift under will, okay? So hiyo ndio shortcut tutumie. Kama mtu anakuahidi kitu, mwambie tuandikishane, okay? Mwambie tuandikishane. That's the shortcut you can use. Unless it's a bequest or gift under will. Then number six, consideration must be in excess of public duty held by plaintiff. Consideration must be in excess of public duty held by plaintiff. Ndio nafikiria zimetosha. Plaintiff held by plaintiff. Consideration must be in excess of. Consideration must be in excess of public duty held by plaintiff. Held by So let's also check on very privity or private of a contract, private of up. And before we go to that, let's check on penal rule. Penal rule, penal rule, penal rule, penal rule, penal rule, penal rule, penal rule. So for your consideration, we have this penal rule whereby payment of the less amount cannot be considered as sufficient consideration, okay? Yeah, if you promise to pay me 1,000, then you tell that your pesa imekaa, let me pay you 800. That one cannot be considered as sufficient consideration. Are we together? That's what penal rule says. So it was a rule that was held in this case that was called penal. There were two people, Penal and Cole, okay? So Penal alienda akakopa pesa kwa, was it Cole or Penal? Yeah, Cole alienda akakopa pesa kwa Penal. He borrowed 8 pounds. He borrowed 8 pounds. And then it was agreed that this 8 pounds were to be returned, but to be returned on 11th November. 11th November. But ikafika tarehe moja when it reached on the 1st November, Penal had a problem, okay? Penal had a problem. So he requested Cole to give him 5 pounds, to settle the problem. On contrary, Paul, seeing that that 11 had not reached, he told Penal that if I pay you 5 pounds, then we'll count that your debt is done. You will not, I don't owe you anything, okay? Yeah, reaching on date 11, Penal went to the court and sued Paul for the balance, and Sue called for the balance. So the court declared that Paul should pay the balance. Paul should pay the balance. That's where this rule comes. So penal rule states that payment of the lesser amount, you say, it states that payment of the lesser amount, is not sufficient consideration. It's not sufficient consideration. It's not sufficient consideration, i.e., as it was held in the case of Penal vs. Cole. Penal vs. Cole. Penal vs. Cole in 1602. In 1602. So exemption of this, exemption of penal rule, exemption of penal rule, exemption of penal rule, exemption of penal rule. Now, where the less amount can be allowed to pay for the full amount, where the less amount can be allowed to pay for the full amount. Number one, where the payment of the lesser sum, is paid in advance, and the creditor accepted the same as full settlement. Where the payment of the lesser sum is paid in advance and the creditor accepted as full payment. Number two, if the lesser sum is paid in different currency, and the creditor accepted the same as full settlement, and the creditor accepted same as full settlement, Number three, where the lesser sum is paid by a third party, and the creditor accepted as full settlement. Number 4, where the lesser sum is paid at different places, where the lesser sum is paid at different places, and the creditor accepted such request, and creditor accepted such request. Number 5, if the lesser sum is paid to addition in an object, if the lesser sum is paid to addition in an object, which creditor accept e.g. in kind, e.g. in kind, e.g. in kind. Ya pale unaambiwa kuna deni yako 1,000, sawa, chukua hii 500 na uchukue unga 2 hapa uende upike. Then we finish that business, okay? So that one is done like that. Then the last one, the second last, introduction of a new element in contract. Introduction of a new element in contract, e.g. a check, e.g. a check will also be exempted. Introduction of a new element in contract, e.g. a check. And lastly, if the debtor enters into agreement with his creditor to compound the debt, if the debtor enters into agreement with the creditor, compound the debt, compound the debt, compound the debt, compound the debt. Then we can also check on another rule, private rule. Private rule. In consideration also, we have that private rule. So it is stated that only parties to the contract can sue or can be sued. It is stated that only parties to the contract can sue or can be sued. The contract cannot therefore confer any legal enforceable benefit or duty on a third party. The contract cannot therefore confer any legal enforceable benefit or duty on a third party. Exemption of that private rule. Number 1, agency. Number 1, agency relation. Number 1 is agency relation. Number 1, the exemption of that exemption. Number 1 is agency relation. Agency relation, you say, it is a contract between an agent and principal. An agent and principal. The contract between an agent and principal. The principal may be sued on a contract entered by his agent. The principal may be sued on a contract entered by his agent. The principal may be sued on a contract entered by his agent. Number 2, we're talking about trustee. Trustee contract. Trustee contract. Trustee contract, you say. Beneficiary can sue trustee. Beneficiary can sue trustee in case of misappropriation. In case of misappropriation of trustee property, even if they were not there, when contract was made, even if they were not there when contract was made. Number 3, negotiable instrument, negotiable instrument, negotiable instrument, negotiable instrument. Negotiable instruments. You say a person who is a holder of negotiable instruments, a person who is a holder of negotiable instrument, e.g. check, can sue if it is dishonored, can sue if it is dishonored, can sue if it is dishonored. Number 4, legal assignment. Legal assignment. Legal assignment, you say, if a creditor assigns his debt, if a creditor assigns his debt to another person, if a creditor assigns his debt to another person, the assignee is entitled to sue the debtor. The assignee is entitled to sue the debtor as if he was the creditor, as if he was the creditor. Then number 5, third-party insurance. Third-party insurance, third-party insurance. Third-party insurance. You say, an injured third party may sue insurance company for compensation. For compensation, even if it was not privity, it was not privity in a contract, even if it was not privity in a contract. We are saying an injured third party may sue an insurance company for compensation, even if it was not privity in the contract, even if it was not privity in the contract. And then lastly, we have restrictive covenant learning with land. Restrictive covenant learning with land. Restrictive covenant running with land. You say a subsequent holder of land, can sue or enforce his rights even if he is not part to the contract, even if he's 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 not part to the contract. So let's check the last part under this is doctrine of equitable or promissory doctrine of equitable. Doctrine of equitable or promissory estoppel, promissory estoppel, promissory estoppel. Promissory estoppel, doctrine of equitable or promissory estoppel. So hizo vitu zishike for consideration. Apart from those rule of consideration, we have a penal rule. Penal rule, we say, is a payment of a lesser amount than that owed, okay? Which we say it is not sufficient consideration, sufficient consideration, okay? Yeah, then we have looked at exemption where now that sufficient, insufficient consideration can be used as a full amount to settle the debt, okay? Then we have privity rule whereby we say that only party to the contract can sue or be sued, okay? Because they understand. But then we have looked at the exemption where now those parties that are not in the contract can sue on behalf of the party on the contract, okay? There are 6 of them. There are 6 of them. Then we are looking at now doctrine of estoppel, whereby someone promised to do something, but due to change of a legal status, he now denies the promise that he promised to do something. Are we together? Yeah. So you say doctrine of estoppel, it was a question you can write there, indicate there. May 2017, question 1A. May 2017, question 1A. It provides that where parties have a legal relationship, and one of them make a promise, where parties have a legal relationship and one of them make a promise intended to affect the legal relation, and one of them make a promise intended to affect the legal relation and to be relied upon by the other, comma, when the other party changes the legal position, he cannot deny the promise he made to the other party. He cannot deny the promise he made to the other party. So condition necessary for application of this, doctrine of condition necessary for application of this. Number 1, there was a legal relationship between the party. Number 2, a new promise or representation is made. A new promise or representation is made. Number 3, reliance upon the representation. Reliance upon the representation or promise. Reliance upon the representation or promise. Reliance upon the presentation or promise. Another one, change in legal position as a result of the reliance. Change in legal position as a result of reliance. Change in legal position as a result of reliance. And lastly, it would be unfair. It would be unfair to estoppel the maker of the promise. It would be unfair to estoppel the maker of the promise. It would be unfair to estoppel the maker of the promise. It would be unfair to estoppel the maker of the promise. I think we can stop there for today, okay? Tamalizia hizo zingine on Friday. We'll finish on Friday. Any questions so far? Any questions? You have not marked the register, please. Then you mark. So we can stop it from there. Online student, any question? Where you have not understood? So let's meet in our next class. Let's meet in